Today is day 2 of jury deliberations in the criminal trial involving former President Donald Trump.
Trump addressed reporters as usual before entering the courtroom this morning, and he aired some similar grievances we've heard from him before, calling the trial rigged. The former president said it looked like they'd be in the courtroom a long time.
And this morning, the jury heard the judge reread the instructions that they requested yesterday. They also heard parts of former National Enquirer publisher David Pecker's testimony, including what he said about a crucial meeting at Trump Tower.
We have team coverage of this case. Criminal defense attorney Caroline Polisi is with us in Studio 57 to provide some analysis. But we're going to begin with Robert Costa, who's at the courthouse in Lower Manhattan. So, Robert, what do you gather here from the transcripts and the jury instructions pages and some of the items that they've asked for, including headphones?
Good to be with you. You never want to read too much into requests from a jury as they deliberate. Sometimes it's just about reviewing the evidence, making sure they have a full understanding of the context of certain witnesses and pieces of evidence. In particular, they're really zeroing in on conversations that were had back in 2015 by Michael Cohen, the longtime fixer for Donald Trump, as well as David Pecker, the former publisher for the National Enquirer, about the setting up of a so-called catch-and-kill scheme to kill any kind of scandalous story about Trump ahead of the 2016 election. And this is at the core of the prosecution's case. And so if they're inquiring about that, it means they're at least taking seriously the argument laid out by the prosecution that Trump participated in a catch-and-kill scheme, allegedly, and was part of these hush money payments made to Stormy Daniels in October of 2016.
Well, Bob, we know that there's a lot of supporters of the former president. It sounds like maybe there's even some nearby you right now protesting. But more tellingly, he's had a string of politicians actually joining him in the courtroom. Who's by his side today? And anything you can tell us about his demeanor?
Trump has been relatively upbeat, flashing a thumbs up here or there. There are no notable politicians here today. There's a park about 10 steps away from where I'm standing. The courthouse is behind me. The park is in front of me. You have some pro-Trump people here for sure. You might be able to hear some of them right now. There are some Trump critics as well. There have been about 15 to 50 people gathered throughout the last 7 weeks of this trial, but it hasn't been some kind of event where a lot of people have congregated. This is in Lower Manhattan. If you're a tourist in Times Square, this is actually a bit of a hike to get to, but you do have people coming here day in, day out. What is notable is there's a lot of security here today in preparation for the verdict. I've noticed more police officers than usual in the vicinity of Lower Manhattan as I took a walk around as we waited for this verdict. Everyone's a little bit on edge, but it's a beautiful day in New York and relatively calm.
Interesting fact there. All right, Robert, you've been talking to sources. What's your assessment of the politics of this moment?
This is an intriguing political moment because the Biden campaign for so long has stayed out of this trial. But as we know, just days ago, had a press conference here with the actor Robert De Niro and a Biden campaign official. And you saw President Biden in recent days weigh in on Trump's conduct and character, really ramping up his argument against Trump ahead of that first presidential debate in June. And you can expect, my Democratic sources say, to hear more about this trial potentially, especially if there's a conviction and Trump's a convicted felon, more about Trump's conduct on January 6th, the classified documents case, all of that as this campaign heats up.
Okay, Robert, thank you.
Caroline Polisi is here with us in Studio 57 with legal analysis. She's a criminal defense attorney and a lecturer at Columbia Law School. So let's talk about the jury instructions, because the judge made a point that you cannot convict someone based on the testimony of an accomplice. In this case, that would be Michael Cohen. So how much is the prosecution betting on the testimony of others, like David Pecker, to help them get a conviction?
Yeah, very standard jury instruction, by the way, for New York State. This isn't out of the ordinary. And that instruction essentially was to jurors, if you convict, you cannot do so based solely on the testimony of an accomplice. And Michael Cohen is considered an accomplice here with those federal election campaign violations of the sort that we've been hearing about all through this trial. So you heard from the prosecution in closing arguments making this argument, Corroboration is the name of the game, because you can convict if the juror finds Cohen's testimony credible and there's additional corroboration. So I think you're seeing that here with the jurors asking for rereading of the testimony of Pecker about that. You know, they're trying to triangulate the meeting, saying, well, is it how David Pecker explained it? Does that match up with how Michael Cohen explained it? That could provide the corroborating evidence if they wanted to move forward with a conviction.
I know Robert said you can't infer too much from these instructions, but we have you. So just, entertain us anyway. I mean, the instructions that were read, we're talking about a huge chunk here. And of course, it's 55 pages. We've got what inferences can be made from evidence, burden of proof, reasonable doubt, violation of tax laws. The judge explained how a person can be responsible for a crime without being the one who physically committed it. What lines are you putting together here? What are you inferring?
Yeah, there's a lot going on there with conspiracy law, especially with the way this crime is charged. Remember, we have that underlying business falsification in furtherance of a secondary crime. That secondary crime that the prosecution has put forward is this election law conspiracy.
There could be three, right?
The crime is the conspiracy through unlawful means, and then there can be three unlawful means. And so that is the area which has been, hotly discussed in the sort of Twitter sphere these days. That those elements don't have to be considered unanimously by jurors. They can decide what those unlawful means are, and they don't have to be the same. They do have to be unanimous, though, on the falsification in furtherance of the secondary crime. So that is pretty standard. A lot going on. 55 pages is a lot to digest and a lot to sort of memorize and not have in front of you. They're not taking it back with them into the jury deliberation room. I think that behooves the prosecution, because they may just, put up their hands and say, well, look, there seems like a lot of bad stuff is going on here. Let's just vote to convict, as opposed to going in a more methodical fashion down each and every element.
Well, that new development today is that request for headphones.
Yeah.
That seems to point to audio evidence. Do you think that means that they're looking at the testimony, what they heard from Cohen's phone? Does that portend well for the prosecution then?
It's so hard to tell. Juries are, each and every one of them are unique, and you just never know what hits, afterwards. And anytime you interview jurors after the fact and you think something landed really well with them, or you feel like a certain piece of evidence was important to them, it's never the case. And when you hear they go off on tangents, I mean, they don't necessarily do anything in a methodical way. That to me just tells me they have acted and behaved very conscientiously throughout this trial. They clearly are paying attention here. They want to do their civic duty adequately. Asking for headphones clearly means, they want to review evidence of some kind, which is good. It's good for both sides if you have engaged jurors that are really taking a hard look at the evidence.
Everybody likes to sort of decide, try and figure out how long this is going to last based on the amount of questions that we've gotten from the jury for readbacks and things like that. I mean, is that typical in a case?
Yeah, definitely typical. It could be, it could be one of two things. They could be going through, we could get more requests for lots more readbacks, or it could simply be there are one or two holdouts on the other side of the rest of the majority of jurors, and they wanted to hear this one readback in order to convince the other two. You just have no way of knowing. Conventional wisdom does say juries do like to reach verdicts on Friday afternoons. Then nobody wants to go into the next weekend, so that sometimes can be a factor. It shouldn't be, but it sometimes is.
So what should we expect today then?
Well, today they're back in deliberations. They've reread the juror instructions. They've heard those 4 pieces of testimony reread to them. As far as I know, there's no more notes. So we might hear nothing until we get that little ding, ding, ding. And that could be their verdict. Or they could say, we want bologna sandwiches for lunch. I mean, there are just a number of notes that they could give to the judge. We just have no idea. We just have to wait and see.
A request for lunch bologna wouldn't be on the top.
Yeah, me neither. I don't know where that came from. Yeah, exactly.
But helpful to understand the range of what that bell could mean. All right.
Exactly.
Caroline Polisi, thank you.
Thanks for having me.